Good afternoon. My name is Brad Hornsby. I'm with the Rutherford County Bar. If I could reserve 3 minutes for rebuttal.
3 minutes. All right, sir, you may proceed.
Thank you, sir. This is a long history, maybe not as long as the case before us, but in 2007, my client was hired at the Madison County Sheriff's Department. She was post-certified at the time, peace officer standards trainings. She was promoted again, became a detective. In about 2014, there was a lot of turmoil in that department. Her best friend's daughter, her best friend's father, was the sheriff, Sheriff Woolfork. So what ended up happening is everybody was either for or against him because he apparently did something wrong. So there was a lot of stress on her with her job. So she went to the interim sheriff and said, "Can I be put on leave? Paid leave." The sheriff never said anything, but they paid her. When the paid leave was expired, she went back to the interim sheriff and said, "Can I be put on FMLA?" Once again, the interim sheriff didn't do anything, but they put her on FMLA. At the end of the FMLA period, she went back and said, "Can I get it extended?" We understand that's optional, but once again, the interim sheriff did absolutely nothing. So the interim sheriff then gets replaced by an election, and we got Sheriff Mayer elected, and that's when this 10-year battle began. Because when Sheriff Mayer got elected, he fired my client on virtually the first day he got into office. His grounds: excessive absenteeism. Never met her, never put her on the work schedule, never asked her to return to work, just fired her. So we appealed it to the county commission, the Civil Service Commission, for the first time, and they ordered her to be reinstated, to go back to her job. The county did not appreciate that ruling, so they appealed it to the chancellor. The chancellor affirmed. So now my client's got an order, she gets reinstated, goes back to work, tries to go back to work. The sheriff now says, "No, you got to be tested by Dr. Davis, excuse me. Dr. Emily Davis, even though she's a doctor, is not a PhD in psychology or psychiatry. She's got a doctorate in education."
What does that got to do with anything?
Well, it doesn't, other than fact, it goes to the credibility, because the commission then makes credibility findings.
Why is credibility an issue in this case?
Well, because the county commission, the second time around, found my experts credible. And
Can the commission do that?
the Civil Service Commission,
Yes, sir.
I think they are allowed to make those type of decisions.
Well, let's
Yes, sir.
walk through that a moment.
Yes, sir.
You've got an exam that Dr. Davis did.
Yes, sir.
Dr. Davis found that your client had failed to pass that exam, correct?
That is what she said, but
Well, no, answer my question.
no, sir. What she said was my client is not eligible to be post-certified.
Okay.
That's
Well,
what she said.
That means that she can't be post-certified, correct?
Well, if she had not met the post standards,
It would help if you would just answer the question.
I apologize. I'm trying to understand where you're coming from, because
I'm trying to
Yes, sir.
ascertain if your client was post-certified.
yes, sir.
Was she?
Yes, sir. There's no evidence.
In spite of Dr. Davis's exam
Dr.
and report?
Davis does not have the authority to
That's not my question. Did
Okay.
Dr. Davis say your client was not post-certified?
was not eligible to be post-certified.
Okay, we agree on that.
Yes, sir.
That's what Dr. Davis said.
Yes, sir.
Was there a remedy that you could pursue at that point in time if you disagreed with Dr. Davis's decision?
If post had indeed attempted to decertify her, yes, there are appellate procedures through post. But the problem is, there is no evidence in the record that she was ever post decertified. She said she was not eligible. And when we actually looked at the testing, both the MMPI-2 test,
Yes, sir. That's not what I'm asking. We have a determination by Dr. Davis that your client was not post-certified,
eligible to be post-certified.
eligible for post-certification.
Yes, sir.
Correct?
That is correct.
There was a method that you could have pursued to have appealed that, I assume.
No, sir.
It wasn't.
Because Post never decertified her.
Okay.
The Peace Officer Standard Training is in Nashville. They're the ones that decertify people.
So it was someone else's responsibility.
It was, if she had been sent to Post and attempted to be decertified, then my client would have had procedures to go to the Peace Officer Standards Training Commission to try to challenge that opinion.
Okay, and the information that the sheriff was presented with was that your client was not eligible for post-certification, correct?
That is what he was told.
Okay.
So the question then becomes is, do we only look at what he knew? Because if we only look at what he knew, then that really doesn't give her any opportunity to appeal his decision. Because when we did appeal it, we did bring in Dr. Aronoff, who did look at the testing that Dr. Davis did and said, I looked at the MMPI test, she's normal. There is no mental defect that she has preventing her from having this job, which is the first standard to be decertified. You have to have a mental defect under the DSM. Her testing under the MMPI and the MCMI-3 test showed she has no mental disease or defect. Dr. Davis does not have the authority or the ability to make those mental health decisions. That is beyond her scope. And that's why it's somewhat important. If she was a psychologist or psychiatrist, she can make those
And you believe that the Civil Service Commission has the authority to make that determination about who's credible or who is more competent to make these decisions?
I think they have the right to look at what the sheriff did and determine whether or not it was proper under all of the circumstances.
That's not the question I asked you.
I think the case that I've cited, Smith, clearly says you don't look at just what happened at the time. You have to look at all of the facts. Because the first time it went back to the second time it went back to the commission, the chancellor had ruled, look at all of the facts. Don't just look at what the sheriff knew. That was the decision the second time it went up to the chancellor. See, don't look at just what the sheriff knew, look at all the facts.
Counsel, would you agree that she had to go through the certification process again for post-certification because of the time period she'd been off? You're not disputing that?
We're not disputing they have the option of having her have what I call a return to duty assessment. There's a return to duty testing and there's the initial post-certification testing. That's the problem that Dr. Davis didn't know there was a difference. She had already been certified. We are not complaining, we've never complained that Sheriff Mayer could not order her to be retested based on the delay. But there's a difference between a return to duty where you're basically saying, can you go back to the job, as opposed to the initial, let's get certification tested.
Is there a mechanism for challenging a decision, an adverse decision with regard to a determination that you're not prepared to return to duty? And is there any mechanism, and you're saying with regard to, if you are stripped of certification, then there's a challenge mechanism. Is there no challenge mechanism if you are denied return within the code or within the regulations?
Well, then we would have gone back to what was the earlier decision was there is an order for her to return to duty. I'm not positive. We never really addressed that issue because I think the issue was Sheriff Mayer had the right to ask her to be tested for return to duty because she had been on leave for a period of time. We're not saying he did anything wrong.
He couldn't have legally returned her to duty, right? Let's say it's a returns certification. If she's not signed off on as being ready to return, I mean, the sheriff would have a problem here in terms of returning her to duty, would he not?
Other than she had never been post-decertified.
But she has to go back through an approval process because of the delay, does she not?
No, sir, it's optional. It is at the option of the sheriff, and that was also conceded at the initial trial. The sheriff had the option of having a return to duty, and that's at least our position at the whole time, that we're not saying he could not test her, he could not do what he did. We're just saying that you have to look at not only what the sheriff knew, but all of the facts, because if you only look at what the sheriff knew at that moment, then you're depriving my client of any legitimate appeal opportunities.
So you're saying then that the sheriff had the option to return her to duty even if she was not, even if she didn't go through the recertification process by post, in spite of the fact she had been off for that many months, for how many ever months it was, 6 months or whatever it was? You're saying the sheriff had the option to do that?
Now, I think then we're at the peace officers, the post commission. I think in that case, we're appealing through the post commission, not through the sheriff, not through the civil service agency.
Okay, well, you say the sheriff had an option. What were you referring
Okay.
to when you answered Judge Usman's question with the sheriff had an option? I'm trying to figure out exactly what you're saying the option was.
He
here.
had the option to require her to be have a return to duty test because of the delay. We think that she had always been certified, post-certified. At the time of the hearing, she was post-certified. She even had a law enforcement job at that time. But because of the delay that she was on FMLA and paid leave and all, the sheriff had the option of doing what I call a return to duty evaluation.
And that's what he requested, correct?
Yes, ma'am. That is correct. He did request that. And that's when we're basically saying, do we only have to look at that, which is what the trial court did. He said, the first time it went up on appeal, the chancellor said basically, no, don't look at just what the sheriff knew. Was there a legitimate basis behind it? Let's look at all the facts. So when it got remanded back to the civil service agents, because the first time up, or the second time up, it's been a bunch of times, the civil service agencies basically focused on what you did, questioned is, what did the sheriff know at that time? The chancellor said, no, let's look at all the facts, remand it. It came up to this court. The Madison County tried to argue exactly what they're doing today, which is, you can only focus on that. You said it was premature, you remanded it back. So in that particular case, it's never officially been decided by this court, but at least implicitly, you affirmed. I'm done with my time.
May it please the court, good afternoon, your honors. Nathan Tilley on behalf of Appellee Madison County. Obviously, we disagree with my good friend here this afternoon and would ask this court to affirm the Chancery Court's decision overturning the Madison County Commission's order. In upholding Sheriff Mayer's termination, the Chancery Court recognized what has already been discussed this morning, the obvious issue here, and that is that because Ms. Barken had lost her post-certification, Sheriff Mayer had no choice. He could not legally continue to employ her as a deputy under Tennessee law. And if you look at the commission's order here that the Chancery Court reviewed, there's not even a discussion about that issue. It's completely ignored. It does not delve into how it can disapprove of a termination when by doing so it is directing Sheriff Mayer essentially to violate Tennessee law by continuing to employ Ms. Barken. And by ignoring that issue, the Civil Service Commission erred in numerous ways as we've briefed. They violated Tennessee law by directing Sheriff Mayer to continue to employ Ms. Barken. They acted arbitrarily and capriciously. They, in essence, substituted their judgment for post. And I think this is the point that your honors were trying to get at just a few minutes ago. The commission made its decision based upon a credibility determination related to Dr. Davis, comparing her credibility with the credibility of Ms. Barken's paid experts. But that is not a relevant inquiry under the facts of this case, because only one person had the authority to say qualified or not qualified under Tennessee law. That was Dr. Davis. She said not qualified.
That determination could be challenged, though, through a process, through essentially determining whether she's properly or whether Dr. Davis got it right or not within a post-determination.
Absolutely, Your Honor, and I would disagree with my colleague. The regulations under post clearly allow for an appeal of a deputy who loses their post certification. Further than that, she could appeal a not qualified, just the simple not qualified decision of Dr. Davis. And if there's any confusion about that, while this was not before this, what I'm about to tell you was not before the commission, this is in the record before this court. There is deposition testimony of a post official that was taken in this case where he explained that they have heard appeals of deputies
So your
who
position,
were found not qualified.
your position is however it's classified, whether it's whatever labels attached to it, whether it's a decertification, it's a denial, it's a not returned qualified, that there is some mechanism for appealing that within the regulations that don't involve a just cause determination going to the commission. Essentially, there's a process through, but however it's labeled, and whether she had no certification, whether she's returning, whether she still had a certification and wasn't appropriately, however it's labeled, there's some conduit through where she should have appealed through the procedures set forth in the regulations, and there would be some mechanism for it.
Absolutely, Your Honor. And I think if she had done that and gotten Dr. Davis's decision overturned, we're looking at a different set of facts at that point. But as we stand here today, 9 years later, Dr. Davis's opinion has never been overturned. It's still there. It's never been overturned. Now, Ms. Barken took a test 6 months later, and she passed that new test 6 months later. And as I was preparing for oral argument this afternoon, I was trying to think of an analogy that would help us as lawyers and judges frame this in a way that maybe is a little closer to us. And so this is what I came up with. Follow me here. If you had a new law school graduate from law school and taken a job with a law firm, that law school graduate enters into a contract, an employment contract with that law firm. And pursuant to that contract, in order to practice as a lawyer at this law firm, you have to pass the July 2025 bar exam. Well, unfortunately for this law school student, she fails the July 2025 bar exam. And her managing partner terminates her. Now let's assume that this firm has a board that you can appeal terminations to. Let's say she appeals. And she hires some experts. And they come in and say, Tennessee bar examiners, they made a mistake. They graded her test wrong. We've looked at it. They made a mistake. She passed that bar exam. That doesn't matter. Because only one entity in Tennessee has the authority to determine whether that law school student can practice law in Tennessee. That's the bar examiners. So that doesn't give the firm the ability to say, there wasn't just cause for termination. We're going to overturn it and allow her to get to work. I don't think it would go well in Tennessee courts for that new associate to practice law because she doesn't have the credentials to practice law. No matter how strenuously that board that she appealed to believes the Tennessee law examiners got it wrong.
What's the effect of her passing the exam 6 months later?
Well, she can then practice law, can't she? But it doesn't change the fact that when the termination decision was made, that there was just cause to make it.
How do you square that with what the Chancery Court directed the Civil Service Commission to review?
The first time?
I'm
Yes.
sort of lost in my
Yes, Your Honor.
first time, second time analysis here.
I believe the Chancery Court was, I believe the Chancery Court was incorrect the first time. We appealed after that first time. This court found that there was not jurisdiction because there wasn't a final order.
I believe you put it more like we punted.
Well, maybe it was a punt, Your Honor. I
think that's how you framed it in your brief,
Oh, okay, well.
to the commission, rather.
Well, the decision was not on the merits the first time we were here. I think the Chancery Court got it right this time. And I think the case law from this court supports that.
How does your understanding of the scope of what the commission, and maybe this is Judge Stafford's question, or maybe I'm just putting words
You'll probably ask it better than I did.
Well, I doubt that. But how does the scope of the remand fit with your understanding of what the commission's appropriate charge was? And this court says it's not a final order, we're sending it back, and it's this broader consideration of additional information, not just at the moment of what was known by the sheriff. So if that's, and here we're in the law of the case again, and if that's what it's sent back for,
Sure.
then how did the commission err in considering things that they seem to have been directed by two different courts to go think about?
I'm going to disagree with one thing you just said. I do not believe this court directed them to. All this court said was it wasn't a final order. I do not believe there's a direction from this court. There was not a decision from this court that said the Chancery Court's decision was correct.
What made it not a final order? Why
Because it was a remand. So this court found because there was a remand, it wasn't a final order and it was not reviewable. We disagreed with that. We argued, but this court disagreed with us. And so it went back down to the Civil Service Commission. To answer your question though, Your Honor, the Civil Service Commission was charged with considering all the evidence. It was not charged with ignoring its role. Its role is to determine whether there's just cause. It doesn't even use the phrase just cause in its order. There's no discussion about whether there was just cause. And so,
isn't all the evidence here, though, the additional doctor's testimony in this case, that there's a mistake, this was bad testing, Dr. Davis got it wrong, we're more qualified than she is, and she messed up here, and maybe the commission shouldn't have considered it, but it seems like the commission may have been directed to consider it.
sure, but it doesn't change the analysis of whether there was just cause. And so, and that's the question, right? And I think that the case law supports us on this. In fact, the case that my colleague just brought up, Smith v. White, I'm sorry, I think it directly says what would support us in this case, because in that case, the employee had been found to be a perpetrator of child abuse by DCS. He was found to be a perpetrator of child abuse. The sheriff terminated him. He appealed his termination to the Civil Service Commission. At the same time, he did what Ms. Barken didn't do. He filed an administrative appeal with DCS related to his child abuse perpetrator finding. Eventually, he got that finding overturned. After he got it overturned, he requested reinstatement with the sheriff, and he was denied. This court said the termination was good, that the sheriff's decision to terminate was the correct decision, because at the time, he had been found to be a perpetrator of child abuse. Now, this court said the request for reinstatement should be reversed, that the sheriff should have considered, because at that time, there had been a new finding. The child perpetrator finding had been taken away. But in this case, no one has ever said that Dr. Dape from Post has said that that finding was wrong. And I want to clarify something. The only thing in the record is she was not post-certified. She testified she was not post-certified. The Dr. Davis's report where she says she's not qualified to be post-certified is in the record. There's nothing in the record, and Ms. Barken offered no proof to suggest that she was post-certified after that finding from Ms. Davis. In fact, she agreed that she wasn't post-certified when she was asked during the commission hearing. So just to clarify, she was not post-certified. And at that moment in time, the sheriff had no choice but to terminate her. I'll also point the court to a few other cases that I think are helpful. One is the City of Memphis versus Civil Service Commission of Memphis case. This is a case we cited in our brief, and in this case, there was a fire chief who was working for the Shelby County Airport Authority who was involved in an incident on the runway, and so the Shelby County Airport Authority removed his security clearance. Well, he couldn't do his job without that security clearance. So the Memphis Fire Department terminated him. He appealed to the Civil Service Commission. This court said that termination, there was just cause, even though this court acknowledged that there were some issues and it was highly questionable whether his security clearance being revoked was done properly. But the court noted, but that was done by a different entity. That was done by the airport authority. The Civil Service Commission doesn't have jurisdiction over determining whether that credential was taken away appropriately or not. The Civil Service Commission is just there to determine, was there just cause? And because he didn't have credentials, there was just cause for his termination. So it's important, and I think it's a dangerous precedent for civil service commissions to be allowed the ability to delve into post decisions and determine, well, we disagree with Dr. Davis. We think she made a mistake. Ms. Barken didn't appeal through post, but we still think it's a mistake, so we're going to disapprove of the decision. That's a dangerous precedent because you're basically saying the sheriff should have violated Tennessee law. I have a minute left, Your Honors. I've concluded my argument unless you have any questions.
See none. Thank you.
Thank you, Your Honor.
There is nothing to appeal to post to. I asked her, did you ever receive a certified letter from post? No. There are procedures that post uses to decertify people. She never received anything from post. That's what she was asked. When we showed up at the hearing, she was post certified again. She had been tested a third time.
Wasn't she informed, though, that she hadn't met the standards in terms of returning and that she was being denied after having assessment testing done? I mean, it's not a mystery to her in terms of why she was fired, is it? Or?
No, and that's why she hired Dr. Aronoff to look at what Dr. Lewis did and said the testing that she did shows no mental disease or defect. None. Because that's the first standard to decertify someone. You got to show a mental defect. She did 2 testings, both of which said she has no mental defect. The second prong is that even if she had one, even if she had PTSD, and unfortunately a lot of police officers have that, you have to show that she can't do the job. Dr. Lewis never evaluated that. So we had that done, and then we did do a second
Position that she could not have appealed, that there's no, I mean, opposing counsel and both sides are putting different labels on this, return, decertification. Is your position that she could not have challenged this process through post?
There was nothing to challenge through post since she had never received notification from post that she had been decertified.
But your client did testify that she did not have post certification at that time, correct?
I don't believe that she did say that. I will respectfully disagree, but I'm not going to be bound by that because I really cannot say that. But because I did ask her the questions, did you ever receive letters from post to try to see if they had initiated the procedures?
Well, I guess what I'm asking you is, opposing counsel says that your client stated at some point, or admitted, may have been the words they used, that she was not post-certified at the time of her termination. Are you saying that she has not admitted that?
No, I don't think post officially decertified her.
That's not my question.
I apologize.
I understand you're saying she didn't get a letter, she didn't get a notice. There may be some question about how her knowledge was or was not obtained. But did your client, is it in the record that your client stated, I was not post-certified when I got fired?
I do not think she did that, but I don't want to be, I respectfully don't want to be bound by that because I just honestly don't remember. I just remember asking her the questions because post is a separate
For
entity.
purpose of argument, let's
Yes, sir.
assume the record says that.
Yes, sir.
If she said she had no certification, and if she had no certification, it wasn't a decertification, it was a return, denial, not certified, however we're labeling it, is there a mechanism to challenge that under post with regard to the regulations that are provided for?
If she had been decertified by post, yes, there are procedures to challenge it through post.
What if she's simply denied on the front end in terms of you're attempting to be certified and they say no?
She basically acknowledged, she said, I'm post-certified when we had that hearing. You know, there are procedures. That is a separate entity that you can appeal through. But Post sends letters, she has a right to hearings, and you have hearings. She says, basically, I never got anything from Post. So that's why our argument is, when it was sent back the first time, the commission was told, look at all the evidence. They did, and they reinstated her. Thank you, sir. Thank you, ma'am.
Thank you, gentlemen. We appreciate your argument. We'll take this matter under advisement and attempt to get you an opinion at the earliest possible time.
Thank you.
Thank you. You may be excused. Sandy, you may call the next case, please.
In re Carl Edwin Osborne Jr., Living Trust.